All right, we're back at part two. Kyle Rittenhouse. The hearing to discuss the motions filed by both Richards and Binger. The judge is not having a good time with this, and neither are the lawyers. But we will. Hello out there. I am trying to get
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dread Show.
And away we go.
The money, the evidence that were the source of the funds with which Mr. Rittenhouse purchased the firearm, is that he wants to prevent that from being offered? Is that any reason you want to offer that evidence?
In other words, this is so ridiculous. Are you sure you want to do this? I mean, this is not even close to being admissible.
Absolutely, Your Honor. The defendant is charged with illegally possessing a firearm. The circumstances under which he possessed that firearm are directly relevant to that charge. So,
Yeah, no.
how he obtained it, how he purchased it, the circumstances under which he purchased it, how he paid for it, etc., all of that is relevant. I believe that there will be testimony with regard to this. I don't think there's any dispute that the defendant turned around and used his stimulus check very shortly thereafter to go up to Ladysmith, Wisconsin with his good friend Dominic Black and essentially gave the money to Mr. Black, who then purchased it on behalf of the defendant because the defendant was 17. He can't legally purchase or own a firearm.
What is the source of the funds? How is that relevant?
Yeah, good question. The charge is possession of a rifle. What money he used to buy the rifle is completely irrelevant. The jury does not need to know that to determine whether it was legal for him to possess the rifle or not. Well, I should be careful. The jury doesn't need to know that to determine whether he possessed the rifle. The judge will decide whether possession of the rifle was legal or illegal later. But suppose that the judge decides that it was illegal for Kyle to possess the rifle. Then the question before the jury was Kyle Rittenhouse in possession of the rifle? That's all that matters. Whether he used stimulus money to buy the rifle is completely irrelevant. Everybody knows that. Everyone except Binger.
It's relevant, Your Honor, because Mr. Black was working essentially as a straw purchaser here, Your Honor.
That's a separate issue. What he's asking and not be allowed is evidence about the fact that he used the stimulus money to buy the gun.
Yeah, I mean, the fact that this could have been a straw purchase is not a matter before the court. What is before the court is minor and possession. And the whole thing about straw purchase, Dominic Black's dealio was a separate trial.
Where's the probative value of that?
Well, Your Honor, I think it paints the picture for the jury of how this transaction occurred.
It doesn't matter how the transaction occurred. All that matters is, did Kyle possess the rifle at the age of 17?
How does Mr. Rittenhouse come into this money? It's a lot of money. We're not talking about $50 here. We're talking about $800 or thereabouts.
Who cares how much? Is he trying to paint Kyle as having done something nefarious because this amount of money is so large? I mean, after all, what's a kid doing with $800? I mean, come on. He must have gotten it through ill-gotten gains. That's what he's getting at.
So it's a large sum of money. Mr.
Actually,
Rittenhouse,
you're providing the explanation. I would think that you'd want to offer the where did they get this money? I don't understand.
we can leave the question open for the jury, Your Honor.
He always does this. Whenever faced with the fact that his own motion is BS, that the evidence is inadmissible, he always comes, well, let's just tell the jury anyway and let them decide. The whole point of having a Sullivan test is to determine whether the jury should hear it. It doesn't do any good to have these motion hearings if you're just going to put it in front of the jury anyway.
And we can let them try and speculate if they want to, but since we already know the answer, why not tell them the truth?
Tell them the truth about what? The jury is not being tasked with determining whether Kyle used the money legitimately or not. The purchase of the rifle is not relevant here. It's possession of the rifle. That's the question in front of the jury.
I tell them anything. I mean, he had money. He certainly had a job as a lifeguard or something, I read.
I don't know that he had that job at that particular time, Your Honor. No.
I don't want to get into
I mean, the defense is going to...
Yeah, the judge kind of left himself open there a little bit. The judge started to go down the path of, well, maybe he got the money for legitimate reasons or whatever. Maybe, and the judge at that point realized, oh, crap, I don't want to go down this road. It doesn't matter. And here I will say this. If Kyle had robbed a liquor store to get the money to purchase the rifle, it would still be ruled inadmissible.
He's going to talk about his work as a lifeguard. We've already heard reference to him, working in our community, although he worked in Pleasant Prairie. But
what is the relevance of the stimulus money being used for that as opposed to being used for drugs or for musical instrument or a boombox, or is it? I don't know.
If we want to cut off reference to that,
is that a current term, boombox? I don't know.
If we want to cut off reference to that, Your Honor, then why don't we just cut off reference to the defendant working in Pleasant Prairie as a lifeguard too?
Oh, come on. If you're going to take that away, why can't we take this other thing away? What kind of argumentation is this?
You haven't given me a reason.
Well, I think it's the same issue. I think it's the same. It's two sides of the same coin, Your Honor.
Yeah, I would tell you that I don't think it's a big deal, but I do think the defense is correct. That it doesn't sound to have much relevance. I also don't. You're suggesting that the reason he's trying to do it is to denigrate the defendant for not using the stimulus money for a more altruistic purpose. I would imagine that some percentage of the American people who got money used it for altruistic purposes, but I would bet most didn't, including some who probably spent it on illegal drugs.
I just don't see how it goes to any element that's in dispute here. I mean, it's just, I think it is to denigrate him, to try and paint him bad, and that's why they put it in the Washington Post article. I believe that's where it was got, or the New York.
Washington Post article. I did, by the way, read that New Yorker magazine article that you mentioned, but I didn't read.
I don't think it's an issue of denigrating or making him look positive. The stimulus money was intended to stimulate our economy. It was designed to be spent at various locations, whether you go out and you buy groceries, or you spend it on your rent, or you buy a gun.
Gee, where has he heard that before?
It certainly benefited the Ace Hardware and Ladysmith to sell that gun. There's nothing wrong with that.
Then you wouldn't have brought this thing up in the first place. But where did he hear this?
Well, why did they give out these stimulus checks? It was to go buy things. And the last thing that they wanted you to do was to put it in the bank. People are coming in saying, oh, he could have used that money to buy food. Well, I mean, he buys food already. So what's he expected to do? Buy more? I mean, he's supposed to go through the drive-through and they ask, would you like to supersize it? No, I don't think I'll oh, wait, I got this stimulus check here and I'm supposed to buy food with it. So yeah, I'll have the supersize. Is that what they were expecting? Well, he could have used it to pay rent. Well, he lives at home. He's 17. I hope he doesn't pay rent to his mother at 17. So what was he supposed to do? Well, the last thing they wanted you to do was put it in the bank. It doesn't stimulate the economy much if you do that. And in fact, that's one good way to just raise inflation. Although giving everybody money is another way to do it. But he was supposed to go in, buy things. And why? Well, this is how it works. And I know that the anti-Kyles struggle with economics. They're probably hanging out on the Marxist side. So let me make this really simple. You see, this is like a dollar. We're going to pretend that Kyle's coronavirus check was actually cash to make it simpler for you. And let's say that this is $1 And this dollar here is called currency, which means that it's transferable. I can give it to somebody, and then they can take it and give it to somebody else. It also has value. So what I mean by that is when I give it to somebody, I can get something that I want in return, you see? And so what Kyle did was he took about 1,000 of these, and he went to a hardware store, and he gave these dollars to the clerk at the hardware store. And the owner was very, very happy. He's got 1,000 of these dollars now. And what can he do? Well, he can give these to his employees, and they can in turn, because remember, it's transferable, they can take these dollars and they can give it to other people to pay for rent. And that way, they can live and happily ever after. And that's how it's supposed to work. And he basically took his money, he went to a hardware store, he bought something with it, and in turn, he helped stimulate the economy. That was the purpose of the stimulus checks.
Gun ownership is legal in our country. Dominic Black purchased the gun. He's legally able to do that. Of course, the defendant isn't, but there's no implication here by the fact that it's stimulus money used to purchase a gun. There's no automatic implication, positive or negative, on that.
Then you wouldn't have bothered to go through the trouble to try to get this entered into the court record. Why are you filing an other acts motion to get the source of the funding into the court proceedings if you didn't think that it painted the defendant in a negative light? You're all but admitting now that it's not even relevant. And you're saying, but it's not harmful. Remember, when it comes to this other acts dealio, what you're comparing is the probative value versus the connotation, the negative connotation that is brought about by the evidence. And here, you're saying it's not probative at all. It doesn't paint the defendant in a bad light. Then of what value is it?
It's exactly what the stimulus money was intended to do, was to be used to stimulate our economy by supporting businesses.
Yeah, I think it's going to elongate the trial. So to me, it's, I'm not going to give you a definitive ruling now because it's not, in my estimation, it's not that objectionable, but it's also not that probative. And I tell you what, we're not going to spend as much time at the trial as we are today talking about this, because we want to move this case along. So if he asks and you object, you're going to get a one-word response as to whether I decide at that given moment in time whether it's, and that may have something to do with the pace at which we're moving. So I just don't want to get bogged down.
So in other words, what he is saying is that during the course of the trial, you use the word stimulus, and the defense objects to it. I'll let you know at that time whether I'm going to go ahead and allow it or not. I'm really surprised the judge didn't put the hammer down on this. This is Finger being his sleaziest. He wants the jury to look at Kyle and think, oh, he's used that money, which could have been used for good things, and he went out and bought a rifle with it. That's what Binger wants to do. And then when the judge calls him on it, all of a sudden he changes his tune. Oh, well, there's nothing wrong with using stimulus money to purchase a rifle. Then why are you wanting this entered into the court record as evidence?
Motion to admit evidence. That is evidence of whether, because Joseph Rosenbaum had been convicted of child sex offense and went to prison for it, I guess three different times, you can start talking with an extreme bias towards denying your request.
Understood, Your Honor.
Okay.
Look at the way the judge is looking at him. Like, yeah, come on, Mark. You know, you're a pretty good lawyer, unlike the idiot on the other side. I can't believe you're doing this. You know I'm going to probably rule against this. And Mark Richards is saying, yeah, I know, but I want to try my best anyway. But the smile he gives is that of sort of respect. He doesn't do that for Binger much.
Your Honor, his status as a felony offender is relevant in this case because based upon the facts of that evening and his conduct. When Mr. Rosenbaum was on the scene on the 25th, he made threats to numerous people, including my client and Mr. Balch, where he specifically said, if I get you alone, I'm going to kill you. And that happened earlier in the evening. It's reported. I received that discovery from the government.
Okay, so that's Ryan Balch. And it looks like that's going to be entered into the court proceedings, into the record. And so this is going to be presented as evidence. Ryan Balch is taking a stand, and he's going to claim Joseph Rosenbaum threatened to kill Kyle Rittenhouse earlier in the evening. And that's going to be tough for the prosecution to overcome.
It was from an FBI agent who interviewed Mr. Balch. Mr. Rosenbaum made other threats about not being afraid to go back to jail. He stated, I just got out that day, which was overheard by my client. And ultimately what ends up happening, and it's on the video, my client is walking down the street, Sheridan Road, towards what I would refer to as car source 3, where the first shooting occurs. As he's walking down that road, Mr. Rosenbaum becomes aware of Kyle. He's been called and asked to go there to potentially put out fires that people are starting at that location.
Let me stop it here for a moment. Joseph Rosenbaum apparently stated numerous times that he was not afraid to go back to jail. Now, he also said that his client overheard it. Now, for that to get entered into testimony, Kyle would have to take the stand. Unless he has another witness who could claim that he heard it and that Kyle was with him at the time, and that would have been Ryan Balch. So the question could be, did you, Ryan, hear Joseph Rosenbaum claim that he was not afraid to go back to jail? Yes. And was Kyle Rittenhouse with you at the time? Yes. Would Kyle, in your estimation, have heard Ryan Balch say this? Yes. The prosecution might object that that's speculation, but whatever the case. Now, it could have been somebody else besides Ryan Balch, by the way.
He asks for...
You say he, you're talking about the accused. Okay, go ahead.
He asks for a fire extinguisher from the gas station at the corner of 60th and Sheridan Road. Somebody provides him a fire extinguisher. He takes off in the direction of 63rd and Sheridan Road, car source number 3. As he's going to that location, Mr. Rosenbaum and Mr. Zeminski are seen on video behind him. And in front of him. My client starts off behind him, goes past them. As my client passes Mr. Rosenbaum has his face covered with his shirt in a ninja type mask, not a COVID mask. It has over the top of his head and a slit for his eyes, hiding his identity. As my client goes by him, there's statements of get him, kill him, things like that. Whatever is said, it's in dispute, but there's something clearly said. As my client is aware that he is being chased, he's also being followed by a reporter by the name of Richard McGinnis. As he's being chased, McGinnis follows him. My client runs into the lot of car source 3. Right before he enters the lot, he's being chased. He drops the fire extinguisher so that he can get away faster, I would submit.
If I'm the judge, I would probably tell him, hey, come on, can you get to the point here? It's almost like he's recreated the entire night. A little tiresome and probably inappropriate, but the judge lets him go ahead and talk.
As he gets into the middle of the car source 3 lot, Mr. Rosenbaum continues to follow, chasing him. He throws something at him, which has now been determined to be a metallic type bag.
Metallic type bag? It's a bag. I think it was a plastic one.
You see it clearly in the video. Mr. Rosenbaum fires it at my client. There's evidence that there was something in that bag that was removed before it's recovered by police, also from a statement from, I believe it's Mr. Balch. My client turns around, addresses Mr. Rosenbaum, still being followed by Rosenbaum chase and Richard McGinnis off to the side. He turns around when Mr. Rosenbaum does not stop, even though he's pointed a firearm in his direction. and begins running away further. And he's looking over his shoulder back at Mr. Rosenbaum, who continues to advance. Richard McGinnis states that Mr. Rosenbaum continues to run at Kyle, even though Kyle is now addressing him and pointing a firearm in his direction. Mr. McGinnis states that he lets out, as he describes it, a blood-curdling scream yelling the F word.
He being?
Mr. Rosenbaum.
Go ahead.
My client, as he's jumping towards him, fires the...
Oh, yeah, this is all very interesting, Mark, but what does this have to do with your motion? You want evidence of his past felony conviction entered in as evidence. What does this have to do with that? It's a very long-winded explanation, and it seems to me more like just a story that Mark likes to tell.
4 shots, which take less than 1 second, hitting Mr. Rosenbaum. Your Honor, Mr. Rosenbaum had the will, he had the intent, and he had stated what his motive was, to take somebody who he believed is a threat, who had put out fires that he had been starting, had been stopping them from burning down buildings, and now was his chance. Mr. Rosenbaum, because of his status as a convicted felon, is unable to lawfully possess a firearm, could not purchase a firearm. He saw this as the opportunity to possess a firearm and take care of what he believed was a threat or a problem to the rioters, not demonstrators, rioters, which Mr. Rosenbaum was.
Yeah, this is speculation. You don't know why he wanted to take the rifle, and I think it's pretty obvious to everyone.
Don't focus on them! Don't focus on them!
At this moment, this is important. I'm going to go back and play this again. Watch what Joseph Rosenbaum says. Now, there's a question. Is it JoJo? I think it is. It sure sounds like him. But let's take a look. Listen.
Don't focus on them! Don't focus on them!
I say we jack them and take they guns. So, jacking them, I'm sure, doesn't mean thank them, greet them, exchange condolences. I have a feeling that jack them means seriously bodily injure them. That's what jack them means. And what is the standard in self-defense in Wisconsin? It's not that you have to fear your life is in danger. You have to fear serious bodily injury. That's the standard. And Rosenbaum is saying, I say we jack them and take they guns. What did Rosenbaum later that night do? He tried to take Kyle's gun.
There's numerous photos earlier of Mr. Rosenbaum wearing a shirt in a proper fashion over his body, not using it as a mask. In the state of Wisconsin, hiding your identity to commit a crime is in itself a crime. He was doing it. Your Honor, the case that I've cited in the brief, State v. Ingram 204 with 2nd 177, and it's also cited in the annotations for the witty cautionary instruction. And I know the court knows that it's your case. It's the fleeing and eluding, and the state sought to put in the fact that he was convicted. In this case, it is our argument that he was trying to take the gun, 1, because it was readily available, 2, he could not legally purchase one. Many of the individuals that evening on both sides of this were heavily armed. There's Black Lives Matter individuals with guns. There's people who are protecting property with guns. There's militia members parading around. It's our position that Mr. Rosenbaum could not legally possess a gun, but that wasn't going to stop or deter him. And, you know, I read the newspapers, I read the stuff, and everybody's, oh, he just wants to put that in to sully the victim. 1, it hasn't been determined.
To sully the victim? Okay, go ahead.
1, it hasn't been determined whether he's a victim or whether this was a justified homicide on the part of my client.
Yeah, whatever. That's a complaint you have against the newspaper. What does that have to do with anything here?
Secondly, under Old Chief versus U.S. 204, United States 177, there could be stipulations that could be entered into. In this case, it doesn't have to be that he's a convicted pedophile. It can be that he was a convicted felon, which serves a purpose. He was stealing a firearm while masked, attempting to, which is a felony in the state of Wisconsin. Theft of a firearm, masked, felon in possession of a firearm are just a list, not to mention attempted battery, things like that, that he was attempting to do that evening to my client before he was shot.
I wonder if in your motion you mentioned pedophile or just felony conviction.
It's highly probative. It explains why Mr. Rosenbaum possibly didn't bring his own gun, why he was seeking to get the gun from my client. And that isn't my client's words. My client would testify to that, but it's an independent witness who the government has listed as a complaining witness, Richard McGinnis, who says he was going for Kyle's gun. And that's in interviews to law enforcement, and that's in interviews to my investigator.
Did you say when you began that there is a witness who reported hearing Mr. Rosenbaum say he just got out of jail that day to the accused?
Here's a clue to Mr. Richards. The fact that Joseph Rosenbaum made a claim here, made a statement about not being afraid to go back to jail, has stirred the judge a little. This might be an opening. Now, if only your entire argument had focused on that instead of rambling on about the entire evening and all the events surrounding whether he was covering his face or whether Kyle Rittenhouse ran into a wall of cars or whatever.
Yes. He said he was announcing it to the people at Car Source 2 where my client was in the property. And it wasn't jail. He had gotten out of a mental institution, what is the evidence, I think.
Well, what institution he was in was not important. What the what the decedent allegedly said is the important thing. He allegedly said what?
He said, words to the effect, I just got out of jail today, I'm not afraid to go back. And
is that in the discovery, I assume?
I don't remember those words. I know he had gotten out of, I think it was a commitment that day, not jail.
A commitment? Okay. He got out of the mental health hospital.
But I don't recall seeing those words.
Go ahead.
In other words, he said it, you just don't want to admit it.
I interrupted you.
Hey, Your Honor, that's the argument. He said it. It's in the discovery, which I was provided by the state. It's reported by numerous individuals, and there's that incident. There's where he's yelling to people, "Just shoot me, N-word." He was not a demonstrator. He was somebody who came to Kenosha, whether he lived here or he didn't, came to the downtown area to wreak havoc on the city. And our position is he ended up attacking our client because our client was alone, and our client ran from him as far as he could. And in the drone footage, you see him run up against a wall of cars. He stopped at that location, and he can't go any further. On the other side of the cars, from the drone footage, you see the demonstrators bashing in the car windows, and he didn't want to run through that.
What does this have to do with your motion? You've got two claims going here. One, that Joseph Rosenbaum said that he was not afraid to go back to jail. Two, that he was trying to take Kyle's gun because he could not legally possess one. None of this has anything to do with that.
He turns around, he addresses Mr. Rosenbaum. After Mr. Rosenbaum's buddy, Mr. Zeminski's already fired the first shot within seconds of Kyle firing.
Mr. Bear.
Look at the face. This has really intrigued the judge. The whole thing about Jojo Rosenbaum claiming he was not afraid to go back to jail.
Judge, there are a lot of people out there commenting on this case that are happy that Kyle Rittenhouse killed a pedophile. And that's the danger here.
Yeah, the danger is the prosecutor mentioning the word pedophile when you could have just said convicted felon.
We don't want the jury to make a determination that somehow this was justified because it got one child molester off the streets. That is not what was going on here.
But you had no trouble with the jury convicting Kyle Rittenhouse because the jury felt that the use of stimulus funds to purchase a weapon was somehow bad. That didn't bother you from filing that motion.
Clarify that Kyle Rittenhouse knew none of this at the time of this incident. Had no idea that Joseph Rosenbaum had ever been convicted of felon, had no idea he was a sex offender or anything like that. So this doesn't go to Kyle Rittenhouse's state of mind. And that's important for self-defense. This is not a subjective issue. This is not a reasonable issue. It does not go to self-defense at all because there's no evidence Kyle Rittenhouse knew anything about Joseph Rosenbaum's history.
That's true.
That night. They had never crossed paths before that night. They'd never met.
And I agree with you on all of what those points that you're making. I guess I'm struggling with, and as you recall, I started by saying that I had extreme bias against the defense position. But I'm struggling now a little bit because I'm hearing about this statement allegedly made by Mr. Rosenbaum about having just gotten out that day and not afraid to go back. If that is in fact testimony that's going to be offered at the trial, it does put a different light on it. Not about whether he's. I would be surprised if I would admit evidence that he was a sex offender, or that he had, the number of times he had gone to prison, or the revocations. However, if indeed there's evidence produced that he had made the statement about just having gotten out that day, that certainly does put a little bit of a different light about it. So you don't have to convince me that about not what was in the mind of the accused, other than the statement allegedly made that he had just gotten out that day. And so why don't you argue on that point?
The judge has gone back and he's really onto this whole thing about Joseph Rosenbaum claiming that he was not afraid to go back to jail. And he turns it over to Binger. He wants him to respond on that point. Look what Binger does.
Sure, Your Honor. With regard to the motive that Joseph Rosenbaum had that evening when he confronted the defendant, because that's where this really goes to. The defense wants to argue that his motivation in confronting the defendant was, among many other things, which counsel's just detailed, a desire to obtain the defendant's gun because Mr. Rosenbaum couldn't get the gun any legal way.
Classic straw man argument. Binger doesn't address it at all. He switches the argument over to the motive of Joseph Rosenbaum to take the gun. Why? He's on safer ground there. He's already prepared that speech. He got a little surprised by the whole thing about Jojo Rosenbaum claiming to not being afraid to go to jail. Binger doesn't have the ability to think on his feet. He had already prepared this whole deal about Jojo wanting to take a rifle to arm himself because he couldn't legally possess a rifle. So he's going to go right on that and he's going to talk. And he sounds like he's real rehearsed on it. Yeah.
That is really what this is. He's a felon, so he can't go to Dunham's or Gander Mountain and buy a gun. He's got to steal it. That's the only reason why this fact of his felony conviction could possibly come in a trial, is to show that motive. So, how plausible is that motive? First of all, we have no evidence that Joseph Rosenbaum wanted a gun that night. None whatsoever. No one is going to testify that he ever tried to get a gun since his last felony conviction, that he ever said he wanted a gun that night, that he ever said anything about wanting to get armed that night. There is nothing in this record as to him saying anything about his motivations with regard to a gun.
The judge should stop him and say, look, I didn't ask you about that. I asked you about his statement. But he doesn't.
Second of all, counsel's acknowledged everybody had guns that night. In fact, earlier in this hearing, counsel referenced a racist statement that Mr. Rosenbaum said. That is on video. Everybody's seen it here in the court. And it's clear Mr. Rosenbaum is walking up to individuals that are similarly armed to Mr. Rittenhouse, that are openly carrying AR-15 style assault rifles slung around their shoulders. He gets in their face. And he is challenging that. This happens on the videos. Now, does Mr. Rosenbaum at any point reach for anyone's gun in that situation? No. Does he try and take it away from anyone? Does he say, let me have that gun? Does he say anything about a gun? No. So I posit, Your Honor, that if Mr. Rosenbaum showed up randomly in Kenosha that night, after having been released, and decided, this is the night of all nights, I need to go get myself a gun because I can't buy it at the store. If he really wanted to steal it, he had the entire evening to steal it from countless people. But he wasn't chasing after Mr. Rittenhouse because he wanted to steal Mr. Rittenhouse's gun. Counsel's already detailed numerous allegations or parts of this story that the defense will try and introduce evidence on that suggests that there were other reasons why Mr. Rosenbaum may or may not have been chasing Mr. Rittenhouse. And by the way, I don't concede the narrative that counsel laid out about the facts here because I think there's more to the story, which we'll get at trial. But at any rate, if you listen to counsel's argument, the allegation is that Mr. Rosenbaum was starting fires. He was trying to destroy property. The defendant was grabbing a fire extinguisher, trying to stop Mr. Rosenbaum. They had multiple interactions, at least one at the car source on 59, and then maybe later on as they're traveling down Sheridan towards the 63rd Street car source.
Gee, you're not painting Rosenbaum in a very good light here.
At any rate, those are all potential explanations why Mr. Rosenbaum may have had a motive to do what he did that night. And they are far more relevant in time, plausible, and consistent with the evidence.
Gee, that's kind of a problem for you because I would think that you're going to try to knock those down. You're going to have to try to paint Kyle somehow as the aggressor. And now you're going on and claiming that there were a lot of reasons why Joseph Rosenbaum may have provoked the entire confrontation. You know, the whole fire extinguisher thing. Yeah, Kyle may have tried to put out a fire. That really angered Joseph Rosenbaum. Are you working for the defense?
Then this obscure notion, this implausible and irrational notion, this unreasonable notion that Mr. Rosenbaum decided this was the night that I need to go get myself a gun illegally on the street, and that's the person I'm going to take it from. I mean, Mr. Rosenbaum, to say that the best way for him to go get a gun that night is to approach an openly armed individual carrying an assault rifle slung around his shoulder and take it from him by force, it strains credibility, Your Honor. Now, in their motion, the defense has suggested that there's some evidence Mr. Rosenbaum was reaching for Mr. Rittenhouse's gun. Now, they didn't mention that here in the hearing, but it's in their motion.
Wait, it was in the criminal complaint that your office filed. In the criminal complaint, it states that Richard McGinnis made that claim. And Richard McGinnis is your witness, not the defense's. So don't try to pass this thing off as the defense's argument. It's your argument.
Well, let's talk about the circumstances of that interaction. Yes, it is on video that at some point Mr. Rosenbaum is running through the 63rd Street car source, chasing after Mr. Rittenhouse. He throws a plastic bag. It's not a metallic bag. It's a plastic bag towards Mr. Rittenhouse, which lands harmlessly 10 feet behind Mr. Rittenhouse as they're running.
I've read that over and over again about the plastic bag being thrown at somebody. Now, if I throw a plastic bag at you, I guarantee it's not going to hit you. And that would be true if you're standing 2 feet ahead of me. So I guess I'm interested in what the images show about the course of the plastic bag. I mean, did it just project a foot and then drop to the ground? Or did it act like a missile in the direction of the accused?
The judge knows this. He's seen the video. He knows fully well that the bag sailed like it had been weighted down with something. So the judge is just calling him out. He doesn't want to come out and say it, but so he's going to ask Binger, now, how did it go? Did it sail? Of course it did. There was something inside the bag. The judge knows it. Everybody knows it.
There was something inside the plastic bag.
There was something inside it.
We've
Okay.
never been able to determine exactly what it was because it was not recovered in evidence. This was a scene where, obviously, because of all
Sure.
the chaos and
The
situation,
point is that it's shown on video.
it flies into the air.
This is not just a plastic bag, which is what the complaint says, a plastic bag.
Sure. It flies into the air. It lands about 10 feet behind the defendant as the defendant is running away. I don't think anyone can reasonably argue that it was a risk to cause bodily harm at any level to the defendant.
How do you know if you don't know what was in it?
I suspect Mr. Rosenbaum threw it out of frustration or anger, but it's not a reasonable threat to the defendant's
My
safety.
question has been answered.
Okay. So then what happens is these individuals run between some parked cars, and there's an allegation in the defense motion that Mr. Rosenbaum is reaching towards the defendant's gun, may have come into contact with the gun, although there's no physical evidence to support that. But at any rate, why is Mr. Rosenbaum allegedly doing that? We don't know. We don't have any statements from him. We have speculation from witnesses. We can speculate by watching the video, but that is all that is pure speculation. Now, I submit that in that circumstance, the most reasonable explanation why Mr. Rosenbaum may have been doing that is the same thing any of us would do if someone pulled a gun on us, is probably try and defend ourselves by pushing the gun away or knocking it away or anything like that. But the notion that in that moment he thought to himself, I'm a felon, I can't go to the store and buy a gun, so I'm going to take it away from this random individual on the street, is utterly preposterous, Your Honor.
His argument is preposterous. The idea somehow that, well, the most reasonable explanation as for why he reached for the gun was to knock it away because Kyle was threatening him with it. Joseph Rosenbaum was chasing Kyle. This wasn't Kyle walking up to Rosenbaum and pointing a rifle at him. Then, if Rosenbaum tried to grab a hold of the rifle, I think almost everybody would say, yeah, that seems like a reasonable thing to do. But if you watch the video of that night, what Joseph Rosenbaum did was not reasonable. He chased Kyle, tried to ambush him, chased him down, and then Kyle turned and pointed the rifle at him because Rosenbaum posed a threat to him. It's all on video.
So I don't think there's any plausibility here. I don't think there's any evidence as to the Sullivan factors of motive, intent, knowledge, anything along those lines here, because we simply don't know. And Mr. Rosenbaum, obviously, is not in a position to answer any of these questions because he's deceased. So we're talking about the motives of someone who can't defend themselves, can't respond to any of this, and that is completely improper.
Your Honor, just briefly in response to some of the more interesting points Mr. Binger made.
Okay, Richards, you're going to now tell the judge, Your Honor, he didn't answer your question. Right?
One, the evidence is timely. It's part of what happened that evening. Two, Mr. Binger talks about there were other incidences where he was with individuals going at them who were armed with AR-15s. The very distinctive thing between those incidents at the gas station on 60th and Sheridan Road and the situation between my client and Mr. Rosenbaum are, my client was alone, it was not well lit. At the gas station where Mr. Rosenbaum is going nuts, yelling, shoot me in, repeatedly, he has to be held back from those individuals with guns. And there are numerous individuals. It's no individual standing alone, he's going at them. The threat regarding I just got out of jail and I'm not afraid to go back was earlier in the evening at Car Source 2. The bag incident, the state can talk about it not being or meaning anything. It was a metallic bag. You can clearly see it fly through the air, lit up from the lights that were in that area.
Are we having the trial now? Move on.
And the client will testify that he had seen Mr. Rosenbaum, this is on video, right in front of Car Source number 2, walking down the road with a huge chain that had been taken off a trailer that Mr. Rosenbaum and other individuals had threatened. So he knows he has something metallic.
So Kyle's going to take the stand? Huh. Okay. Now, a lot of people would say, that's crazy. Never put your client on the stand. Yeah, that's not always true. Of course, he could have just misspoken here, and he probably did. I would not expect Kyle to take the stand, but I have a feeling Kyle would probably do pretty well.
And he talks about Mr. Rosenbaum defending himself and it being rational. Your Honor, it's not rational to chase somebody unarmed with a firearm. But he chose to do that. And he lives or dies with the consequences.
Terrible legal argument. That's the kind of stuff you see on Twitter.
In this case, he died with the consequences, trying to take a firearm from an armed individual. And we can say, the state can say it's speculation, and I can say it's not speculation. He wanted a firearm. That's why he was masked, and that's why he attacked someone who was by themselves, who was on the other side.
Well, I certainly you're welcome to pursue the evidence and attempt to prove that the decedent was attempting to take the gun from the accused. But I think that he was that there are a universe of motivations that Mr. Rosenbaum could have had, and to invite the jury to speculate that it was because he couldn't legally acquire one, that's too much for me. So I'm gonna grant the. I guess it comes in here as a request on your part to admit that evidence, and I'm going to deny that request.
So Binger used the straw man argument, pushed the argument away from what Joseph Rosenbaum said that night to Joseph Rosenbaum's motive. Richards never picked up on that, never alerted the judge to that what was happening. The judge never did go back and say, hey, you didn't answer my question. So score one for Binger there. It's a small victory because very few people thought that Mark Richards had any chance of getting that motion passed. And frankly, I don't think it's that crucial to his case. But still, okay, the judge didn't give Mark Richards everything, unlike what a lot of people are saying. Like my video, subscribe to my channel, and stay tuned for part 3.